Welcome back to the deep dive. Today, we're tackling that heart-stopping moment for any contractor. When they review their own winning bid and realize there's a massive, potentially business-ending mistake in the numbers.
It's a nightmare scenario.
Absolutely. So our mission is to dissect the legal escape route they might try, the defense of unilateral mistake. We're really digging into how courts tell the difference between, say, an honest adding error and just a bad bet.
And that line is incredibly fine. It's crucial, especially in public works projects where you can't just let bidders walk away easily. But you also can't force someone into a contract they genuinely didn't mean to make.
Right.
So to figure this out, we have to use this multi-part test from contract law. We'll look at key cases like Kemper Construction and really break down White v. Berenda Mesa Water District. We'll focus hard on two tricky ideas: what counts as a mistake of fact versus a mistake of judgment, and what does neglect of a legal duty actually mean in this context.
Okay, sounds good. Let's start with the basics. Before we get into the messy details of a real case, what's the fundamental rule here? What does a party absolutely have to prove to get out of a contract because of their own mistake?
Okay, so the general rule, coming from law and court cases, sets a pretty high bar. To rescind, to basically withdraw the bid, the contractor needs to prove all 5 things.
5 elements. Right.
Okay. First, the mistake has to be material. It has to be significant to the deal. Second, the mistake can't be because they neglected a legal duty. Third, forcing them to go through with it would have to be unconscionable, like really unfair. Fourth, the other party, the one who didn't make the mistake, has to be able to be put back in the position they were in before the bid, what we call in statu quo.
Makes sense.
And fifth, the mistaken party has to give prompt notice they want out and offer back anything they might have received.
That is quite a checklist. Let's see if this actually works in practice. Let's talk about Mr. White's situation. I imagine not all 5 elements are usually the big fight, right?
Exactly. Often, things like giving notice quickly or the mistake being big enough, material enough, those are kind of obvious. The real battleground tends to be element 2, that neglect of a legal duty part, and maybe element 3, the fairness or unconscionability aspect.
Okay, let's analyze White v. Berenda Mesa Water District. First, what are the legally dispositive facts? Lay out the key details for us.
Sure. So White submitted the low bid for building a water reservoir. His bid was $427,890. No, that was really low. About $66,000 lower than the next guy, and almost $85,000 under the project engineer's own estimate.
Wow, that's a big gap. Red flags probably went up.
You'd think so.
Yeah.
White double-checked his numbers and found a huge error in item 13, which was the excavation cost. He'd assumed only about 7% of the dirt was hard rock, like 10,000 cubic yards.
Okay, where did he get that number?
Well, partly from looking at some soil reports, plates 3 and 4, but the contract specifically said those reports weren't guaranteed. He also apparently called the engineer, Mr. Thomas. But the main contract plans, sheet 10, clearly show the excavation site cutting right into a big hill that was almost all hard rock. The real amount was closer to 50% hard rock, or maybe 110,000 cubic yards.
Oh, wow. That's not a small difference. 10,000 versus 110,000.
Exactly. So White realized this before the district formally accepted the bid, and he immediately told him he needed to withdraw it.
Okay, huge factual error there. So what was the core legal issue the court had to decide?
The legal question was pretty specific. Was White's mistake failing to properly connect the dots between those non-guaranteed soil reports, the engineer's comments, and the actual controlling plans legally enough to let him rescind the bid? More pointedly, was this a mistake of judgment he was stuck with? And did his failure amount to neglect of a legal duty that would bar relief?
Got it. What rule of law did the court apply here? Can you state the full rule again and break down its elements as the court saw them?
Right. They applied that 5-element rule for rescission based on a mistake fact we just talked about.
Yeah.
Materiality, no neglect of legal duty, unconscionability, ability to restore the status quo, and prompt notice.
Okay.
And crucially, the Water District actually conceded 4 out of the 5. They basically said, okay, yeah, the mistake was big, enforcing it would be unfair, we can go back to square one, and he told us quickly.
So they admitted almost everything.
Pretty much. That left only 2 things for the court to really wrestle with. Number 2 was their neglect of a legal duty. And connected to that was the mistake one of fact or judgment.
Thank you. Now for the court's elemental analysis. Let's go step by step. Let's tackle that big one first. Neglect of a legal duty. How did the court analyze White's carelessness? What was the standard?
Okay, so for this element, the court had to figure out how careless is too careless. The sub-rule here is really important. It's not just any carelessness that blocks rescission. It has to be serious, like gross negligence or failing to perform a specific legal duty, not just, sloppy business practice.
So not just any oops.
Exactly. The court looked at what White did. He relied partly on those plates 3 and 4, the ones explicitly not guaranteed, and he didn't perfectly match them up with the controlling sheet 10. The district hammered on this, saying that was clear neglect.
Yeah, I mean, the contract warned him about those reports. How did the court justify saying that wasn't neglect of a legal duty? It seems like he ignored a clear warning in the contract documents.
That's the million-dollar question, right? And the court's answer was pretty significant. They decided his failure to perfectly reconcile these somewhat confusing documents was just ordinary negligence.
Ordinary negligence.
Yeah. They basically said it was the kind of mistake that, and I'm quoting loosely here, will sometimes occur in the conduct of reasonable and cautious businessmen. Because it wasn't gross negligence and he hadn't, deliberately ignored the main plans, the court said this mistake didn't count as neglect of a legal duty.
So ordinary screw-ups are forgivable, but really bad ones aren't. The level of carelessness matters immensely.
Precisely. It keeps the door open for relief if the error, while maybe avoidable, wasn't reckless.
Understood. Now, what about the second contested element? The nature of the mistake itself. Was this an error of fact or judgment? How did they slice that?
This distinction is often key. Generally, the law is more forgiving of mistakes of fact, like clerical errors, typing the wrong number. It's less forgiving of mistakes of judgment, like underestimating how long a job will take or misjudging the market.
And the district argued this was judgment.
Naturally. They said White just made a bad call, underestimated the difficulty, the cost, a business judgment error.
But the court disagreed.
They did. They called it a mixed mistake of fact and of judgment.
A mixed mistake. Okay, explain that. Sounds like the court trying to have it both ways.
It can seem that way, but their reasoning was about the root cause. Yes, his final price involved judgment, but that judgment was based entirely on a fundamentally wrong understanding of the facts on the ground, specifically the amount of hard rock.
So the factual error came first.
Exactly. He thought there were 10,000 cubic yards when there were actually 110,000. That's a mistake about an existing objective physical condition. That factual misunderstanding drove the bad judgment on price. The court basically said the label factor judgment shouldn't be the deciding factor when the underlying mistake about reality is so huge, and enforcing it would be, in their words, grossly unjust.
So the underlying factual error tainted the subsequent judgment.
Okay.
And after analyzing all the elements, finding the negligence was only ordinary and the mistake was rooted in fact, what was the court's final conclusion?
The court reversed the lower court's decision. They concluded that since White's negligence was just ordinary and the mistake was about a fundamental material fact, the rock quantity, he met the requirements for rescission.
So he got his bid bond back.
Yes, he was allowed to withdraw the bid and recover the $42,789 bid bond. He wasn't forced into a contract that likely would have bankrupted him.
Okay. This distinction between fact and judgment is critical but can be fuzzy. Let's try to make it stick with some more visceral hypotheticals. Imagine a huge, complex sewage system contract. Big money involved.
Okay.
Scenario 1. A contractor calculates the cost for all the necessary piping perfectly. It comes to $500,000. But when his assistant types up the final bid, they accidentally type $50,000 instead of $500,000. Simple transposition error.
Right. That first one is your classic mistake of fact. It's a mechanical, clerical error, like the Kemper case, basically. The contractor never, ever intended to agree to do the work for $50,000. Relief is almost always granted there.
Makes sense. Now, scenario 2. Same $500,000 correct estimate for the piping. But this contractor thinks, you know what, I bet global steel prices are going to totally crash next month. So purely based on that market gamble, they submit a bid of $400,000, hoping to buy the pipe cheaper later and make a killing. But oops, steel prices actually go way up.
Scenario 2. That's a pure mistake of judgment. It's a gamble about future market conditions and economic prediction. Relief is almost never given for that. The contractor intended to bid $400,000. They just regret the bet they made.
So the key is intent regarding the bid number itself versus intent regarding underlying assumptions.
Largely, yes. White adds the nuance that if your judgment, the $400K bid, is based on a massive factual error about the present reality, like thinking there's only 10K yards of rock, it might still be excused. But pure speculation about the future, That's on you.
That really clarifies it. White is for misreading the map, not for misreading the stock market ticker.
Well put. Okay, so for everyone listening, especially if you're studying this, let's synthesize this into a kind of diagnostic checklist for tackling unilateral mistake problems. Step 1, issue spotting. See a bidder regretting a low bid due to an internal error. Immediately think, 5-element test for unilateral mistake precision. Step 2, the materiality check. Was the mistake big enough in dollar terms? A few bucks. Probably not material. Tens or hundreds of thousands, like in white. Clearly material. Usually an easy one. Step 3, the negligence test. This is often the main event. Was the bidder's mistake due to gross negligence or just ordinary negligence? Ordinary, like struggling with confusing plans, white, might be excused. Gross, like ignoring clear instructions or duties, probably not excused. Step 4, the mistake type test. Was it a clerical slip-up, fact likely excused, or was it a bad estimate or market gamble, judgment likely not excused? Or was it a judgment based on a fundamental misunderstanding of existing objective facts, mixed, argue for relief using white? And finally, step 5, the equity check. Would forcing the deal be unconscionable? Look at the bid disparity. If the mistaken bid is way lower than others, the other party might have known or should have known something was wrong. That weighs heavily in favor of letting the mistaken party out.
So, pulling it all together, what's the big takeaway for you listening? It seems it's less about sticking rigid labels like fact or judgment and more about looking at the whole picture, the nature of the error, the level of carelessness, and the overall fairness.
That's right. The courts are trying to balance things. They don't want contractors using, oops, I made a mistake, just to escape a deal they regret. But they also don't want to enforce agreements that were based on a fundamental, unintentional error, especially when it leads to a grossly unjust outcome.
Okay, here's a final thought for you to chew on. The court in White let him off because his negligence was only ordinary, even though he relied on documents the contract said weren't guaranteed. What if the contract had language like, failure to personally verify all quantities against Sheet 10 shall constitute gross negligence and bar any claim for mistake? Could the district basically write the definition of negligence into the contract and close that escape hatch? How much power does the drafter have there? Something to think about.
Thanks for joining us on The Deep Dive.